Hello my dear friends and a very warm welcome. Today's video session is an overview of the subject of constitutional law, and we are going to assess this subject on a macro level, and we will try to understand the various fundamentals associated with this subject, and broadly speaking we will get an insight into the nature of what constitutional law as a subject of law is. Now, when you hear the word constitution, what is meant by it? Now, it's very important to understand one thing, that any constitution of any country happens to be the most fundamental legal document of that country. It is the grand norm, and every other law, every act has to subscribe to the constitution. Everything trickles down from this grand norm or from this most basic fundamental legal book. Secondly, a constitution defines a very important function, and that is it tells us what the nature of a nation is, whether it's a colony, whether it is a political independent nation, that is whether it's a republic or not, whether it follows a system of monarchy as is followed in various countries of the world, like India happens to be a republic. So we find all these definitions regarding the nature of our nation in the constitution of our country. Then it will also tell us how the various government agencies are supposed to function, what are going to be their powers, what are going to be their privileges, and at the same time it also tells us what are going to be the limitations if certain organs have been given various powers and functions and privileges. Then at the same time the constitution has also put certain limitations on their working so that they never supersede their area of jurisdiction. Another thing that it tells us is how leaders will be elected. What will be the mode of choice? Will everybody get to vote? Will a certain age group be defined beyond which people can vote? And can there be any differentiations as far as voting rights are concerned? Whether there will be a direct form of election or not, or whether there's going to be an indirect election. So our constitution clearly tells us that we will follow the system of universal adult franchise. That is, every Indian citizen who is above the age of 18 years can take part in the voting process. Also, to which offices there's going to be an indirect election, to which offices there's going to be a direct election, is all prescribed by the constitution of our nation. Then it tells us how long will leaders stay in office. So it talks about how our representatives have to be elected. Then it also tells us the duration of stay in office, because at the end of the day they are accountable, they are answerable and responsible to the voters. So for how long a period do they get so that they can prove their worth to the voter, and after how much time re-election will take place is all specified under the document called constitution. Another thing that the constitution tells us very clearly is as to how laws will be given recognition, who will create new laws, how the existing laws should be recognized, and how can amendments or changes be made to the laws which already exist. So either the legislature can create a completely new law in order to cater to the changing needs of society, or it can make certain small changes into an existing law or prevalent law in order to adjust with the changing needs of society. And it will also very clearly tell us what rights are available to the citizens of a nation, what rights will be available to those who are not citizens of India. So it very elaborately gives certain rights to all the people in our country, whether they are citizens or non-citizens, and some rights are exclusively reserved for the citizens of our nation. Now, if we try to understand constitution as a legal document, if we take a look at the slide, we'll understand that it has been divided into the following. It has a preamble, then the constitution is further divided into articles, it has schedules, and then there are appendices. Now the preamble is the introduction to our constitution. Articles basically lay down specific laws and regulations, and the term article instead of section is used in order to bring out the sanctity of constitution as a legal document. Then we have schedules, and then there are appendices. Now, as far as articles are concerned, they are further divided into parts. So parts basically club those articles which deal with the same concept. Like if I would say part 2, article 5 to 11, they all deal with citizenship. So the heading that is given to part 2 is citizenship, because under this part article 5 to 11 will only deal with the aspects related to citizenship. Similarly, there's part 3 which is only dealing with fundamental rights. Then we have schedules which are basically 12 in number, and there are important schedules like the 7th schedule, which talks about the distribution of power between the union government and the state government. Then there is the 8th schedule, which talks about what are going to be the officially recognized languages of our country. And appendices is the plural term for appendix, and basically constitution has 5 appendices. That is, it is supplementary information which is given at the end of our legal document known as the constitution. So this slide basically explains the structure of the constitution as to how it has been divided and subdivided in order to bring out clear classifications. Now, currently, there are 448 articles, and these articles have been subdivided into 25 parts. We will find a list of schedules at the end of the constitution, and these schedules are 12 in number. So if our constitution is talking about distribution of power between the union and state, as I explained to you in the previous slide, that it is the 7th schedule which tells us what powers will be distributed, what subject will be allotted to the union state, what subject will be allotted to the state government. Then appendices, as I told you, is supplementary information attached at the end of a document. And till date, as I speak, we are considering the 122nd Amendment to the Indian Constitution, which is on the Goods and Services Tax Bill. Moving ahead. Now, Constitution is performing a very important function, and that function is of regulation. Now, what is it regulating? First of all, it is regulating the relationship among the 3 organs, and these 3 organs are legislature, executive and judiciary. So it is regulating the relationship within the government machinery. And on the other hand, it is also regulating the relationship between government on one side and the citizens on one side. So there is a mechanism of intra-regulation and of inter-regulation. Moving ahead, if you look at this slide, it lays down the text of the preamble, and we the people of India basically signifies that it is the people of India who hold the political authority in our country. And the 5 words, if you read these: sovereign, socialist, secular, democratic, republic, they very clearly tell us the nature of our nation. In a sense, it explains what India is all about. It's sovereign, that is, it is completely independent in all internal and external matters. The socialist word tells us what our economic policies are going to be, that is the economic nature of our country. Secular means that India does not have an official religion of its own. Democracy, of course, means a government of the people, for the people and by the people. And finally, it talks about India being a republic state, which means the head of our country is going to be elected, and that we are an antithesis to the system of monarchy. Then the preamble very clearly tells us that the following things are being guaranteed to anyone who is within our country, that is justice, liberty, equality, fraternity. Now, what we have to understand is that our preamble has been amended once by the 42nd Amendment Act, and it added 2 new words as far as this part of the preamble is concerned, that is socialist and secular. And the word integrity was also added by the 42nd Amendment Act to our Constitution. Now, there was a huge controversy as to whether the preamble is a part of the Constitution or not, but this was finally laid to rest by the case Keshanand Bharti versus State of Kerala, and it says that preamble is a part of the Constitution, and the Constitution should not only be read but it should also be interpreted in the light of the grand and noble vision expressed in the preamble. Also, this case is really important because a lot of times this question is asked: for which case a 13 judge bench was formulated, and a 13 judge bench till date has only been formulated for the Keshanand Bharti case. This happens to be the largest bench constituted ever in the Indian judicial history. Now, this slide, you see a triangle and you see a circle. Now I am going to be explaining to you the supremacy of constitution from two different aspects. Now first of all, what you have to understand is that this document constitution, if we view our system as a pyramid, it happens to be on the top, it rests on the top, it's that grand norm. And as per this grand norm, not only will the executive function, but also the legislature, and also what is going to function? The judiciary. So all these three organs, as far as the pyramid is concerned, come under the Constitution. They cannot indulge in any act which supersedes the word of the Constitution. Another thing that I would like to explain is that Constitution basically sets out a limit for not only the acts of the government machinery but also of the citizens. Now, nothing can go outside the limits that have been prescribed by the Constitution of India, whether these limits pertain to formulating a new law, whether this pertains to actions of people who form the part of the government, whether this pertains to how a citizen has to behave. So laws and actions of citizens and government officials all have to confine themselves within the word of the Constitution. And from this slide we can understand that from every aspect the Constitution happens to be the supreme legal document and guiding force of our country. Now, our Constitution tells us a very important thing, that is, it upholds the concept of rule of law. How do you understand rule of law? Our very preamble talks about the first 2 points. That is, it talks about social, economic and political justice, and it talks about equality of status and opportunity for all the citizens of India. And the preamble is also guaranteeing to us fraternity and dignity of individuals in India. So all these three are equally available to citizens of India, and this highlights the concept of rule of law. And rule of law simply stands for the fact that there is going to be an equal application of laws to all the people, and no one is going to be above the word of law. That is, nobody is going to be treated unequally or partially as far as application of laws are concerned. Another factor in the Constitution which ensures rule of law is that fundamental rights are ensured to every citizen of our country, and in case your fundamental rights are violated, the violation may come from an individual or it may come from a government agency. You can take recourse to Article 32 and 226, which talk about writ jurisdiction of the Supreme Court and High Court respectively. Now, you can approach the High Court and Supreme Court directly the minute your fundamental right is violated, and you don't have to follow the usual mechanism of approaching the lowest court, because the fundamental rights are guarded very, very heavily by the judiciary of our country, because the Constitution demands so. Hence, all these factors mentioned on this slide ensure that there is the prevalence of rule of law in our country. Another thing that our Constitution lays down is separation of power. Now, separation of power basically means that powers should not be focused in one individual or one organ. That is, one agency should not be given all the powers. Otherwise, the judge and the thief might be the same individual or might be the same organ. Now, if you look at this slide, there has been a clear separation of power between the judiciary, the executive wing, and the legislature, that is the parliament. Now, the theory of separation of power was basically set out by a very eminent jurist, Montesquieu, and India has applied the theory of separation of powers by supplementing it with the theory of checks and balances. So, there is not only a clear demarcation of powers between three organs, but they also maintain a check on each other so that there is constantly um, a mechanism to ensure that none of the organs supersede or overstep their allocated powers. Moving ahead, we have the concept of judicial review. Now, the power of the court to determine the validity of acts of either the legislative or the executive departments is known as the concept of judicial review. Federal structure. Now, the concept of federal structure means that there is going to be government at multi levels. So India has a federal structure, we have a government at the union level, the state level, and by virtue of the 73rd and 74th amendment, what is unique is that we also have a government at the local level in the form of village panchayat or municipalities in urban areas. Now we're talking about multi-level governance, and what else is done is every level of governance has a constitutional basis, and not just that, it also has responsibilities. Now, what is really essential to maintain a strong federation is that there has to be a written constitution which clearly divides these powers and functions between various levels of governance. Then there has to be an independent judiciary, because only an independent judiciary can decide upon disputes in case there is an encroachment of power between these level of governance. Now, the Indian judiciary is completely independent. It's the most outstanding feature of the Indian judicial system. We not only have an independent judiciary, but we also have an integrated judiciary. So that means the Supreme Court is at the top and followed by High Court. Then there are lower courts and district courts and various tribunals. Tribunals are basically those courts which have been created to deal with a specific class of cases. Now, recently the National Green Tribunal has been in news, and it is specifically taking up environmental matters. But the ultimate power as far as judiciary is concerned trickles down from the Supreme Court, because it happens to be our biggest check. Now, the Supreme Court rests on the top, and it is also known as the guardian of our constitution, because it ensures that the letter of the constitution, the spirit of the constitution, is not violated, and that is how the Supreme Court and the high courts have been given the power to exercise judicial review in case there is any deviation or violation of the word of the constitution. Another thing that our constitution tells us is that there is a parliamentary system. Now, parliamentary system means that the executive wing, that is the Prime Minister and the Council of Ministers, will be chosen from the legislative wings. So the legislative wing basically consists of members of parliament, either members of Lok Sabha or members of Rajya Sabha. So our Council of Ministers have to be members of either the Lok Sabha or the Rajya Sabha, and the same goes for the Prime Minister. The unique feature of a parliamentary system is that the executive will remain responsible to the legislature. That is why the functioning of the government is constantly questioned on the floor of the House in a parliament. It is ensured that the government remains accountable and remains responsible to the voters who choose them with a lot of trust. Now, there are certain important dates that one must remember as far as the constitution is concerned, that The Constituent Assembly, which drafted our constitution, the most important legal document, it was constituted on the 16th of May 1946. Then the constitution was adopted and enacted on 26 November 1949, and it was finally commenced on 26 January 1950. 26 November every day is celebrated as Law Day in our country, and 26 January is, of course, as we all know, celebrated as Republic Day. It's known as Republic Day because India proclaimed in front of the whole world that it is now going to be a republic, and it has broken free from the shackles of colonialism, because we all know that for a very long time we were under the British rule. So 26 January 1950, historically speaking, was a proud day for all of us, because we proclaimed ourselves to be a republic, where we declared to the entire world that now we will be electing our leaders ourselves, and the republic head of our country happens to be the President of India. With this, we come to a very important aspect that we need to understand, that is how the constitution happens to be supreme, and any other law, rule or regulation cannot go outside its periphery. This case law, Shreya Singhal versus Union of India. Now, Shreya Singhal had filed a public interest litigation in the Supreme Court, where she challenged the constitutional validity of Section 66A of the Information Technology Act of 2000. Now, at the end of this public interest litigation, when the Supreme Court gave its judgment, it made one thing very clear, that Section 66A was clearly in violation of Article 19 of the Indian Constitution, which guarantees the freedom of speech and expression. And this case study is very important in bringing out the fact that anything which goes outside the boundary or limitations set out by the Constitution will be struck down as being invalid or unconstitutional. So, as a result, the sanctity of Article 19 prevailed, and Section 66A was struck down, and it brought back the freedom of speech and expression on the internet or any kind of computer resource. Now with this, we have come to the end of this video session, which spoke about the overview of the Indian Constitution. Thank you so much for your valuable time, and we will look forward to your feedback.